And I rise to speak in support of the Expungement of Historical Offences Amendment Bill 2025. And although maybe my contribution's a bit more lengthy than I had initially expected, I'll try and keep it as brief as possible so as not to further delay the expected passing of this overdue and very important step in redressing the wrongs of the past that have such an enduring impact, whilst at the same time trying to give this matter and the people affected by it the acknowledgement and empathy that they deserve. Mr. President, I want to acknowledge the trauma and suffering endured by those who were charged and convicted with now expunged homosexuality and cross-dressing offences. I'm sorry this happened to you. I also want to acknowledge the impact on families and friends, Mr. President. I'm also sorry that you have endured this too. I recognise that this can be a difficult topic to talk about and hear about, and is one that may trigger challenging emotions. If this happens, I encourage people to recognise that it's an entirely reasonable response to a challenging topic and employ their usual coping strategies. And if the challenging emotions continue to be troubling, please reach out to Support Services for Help, Lifeline on 131144. Mr. President, amending the Expungement of Historical Offences Act 2017 to provide a redress scheme for those who have had charges and convictions expunged is the right thing to do. I'm sorry it's taken so long to arrive at this place where we are more meaningfully recognising the harm that charging and convicting people for homosexuality and cross-dressing caused. Some 28 years ago, as we've heard the leader outline, we finally acknowledged that homosexuality is not a crime, when homosexuality was decriminalised in 1997. Cross-dressing was repealed 4 years later, in 2001. Relatively recent history, all things considered, Mr. President. It's frightening to think people could have still been charged and convicted of these things when I was going through high school and college. I'm sure some of the students joining us here today might find it surprising to hear or to learn, if they're not already aware, that once it was an offence, it was against the law to be gay. And I'm sure they'd all agree how absolutely wrong that is or was. It's reassuring to think how far we've come socially since that time in accepting diversity in sexual orientation. And listening to Rodney Croom at the Gender and Equality Committee hearings and again today in the briefing made me realise how much I'd taken for granted the relative acceptance of diversity that I've grown up with in my lifetime. And certainly Rodney's advocacy over many years has played such a massive part in creating this greater acceptance, and I'm so very grateful for his courage and selfless and tireless efforts. So thank you, Rodney, from me personally and on behalf of the people I represent. But I also acknowledge that we still do have some way to go, and I appreciate the work of Equality Tasmania and all of the advocates who stand up every day to remind us of this, with their support for and promotion of equal rights and opportunities for gender diverse and the LGBTIQ+ community. Mr. President, some 20 years after we decriminalised homosexuality and cross-dressing, the Expungement of Historical Offences Act was passed in 2017, further recognising that criminalising consensual homosexual conduct was not right and providing a mechanism for charges and convictions to be removed from criminal records. I'm sorry that took so long too. 20 years on from our declaration that homosexuality is not a crime, and 28 years on from our declaration that homosexuality is not a crime, and 20 years on from providing the right to wipe charges and convictions from criminal records, we are now finally, through this bill, providing the opportunity for a redress payment. It's overdue and it's important. In fact, payment to those whose records are expunged was recommended following an independent review of the operation of the Expungement of Historical Offences Act undertaken in 2020. 5 years ago, this Parliament received a report from independent reviewers, Ms Melanie Bartlett and Ms Taya Catala-Jones, who found that there had been just 10 applications to expunge historical offences. 9 were deemed ineligible as the offences were not homosexuality, public morality or cross-dressing offences as defined in the Act. Rather, they were offences including, but not limited to, drug possession and supply, common assault and dishonesty. 1 application was refused expungement as the Secretary was not satisfied on reasonable grounds that the conduct constituting a homosexual offence, if engaged in by the applicant at the time of making the application, would not constitute an offence at the time of making the application. So whilst we had come so far as to decriminalise homosexuality and cross-dressing and provide for it to be expunged from criminal records, it appeared those eligible for expungement were not applying. The independent reviewers concluded that a payment should be made available for those whose records are expunged under the Act. part of Recommendation 13 reads, and I quote, "The independent reviewers recommend that the government introduces a one-off ex gratia payment of a fixed amount as acknowledgement and redress for applicants who have charges and convictions expunged under the Act. This payment should be available automatically on the finalisation of an application in which the Secretary has determined to expunge any charge or conviction," end quote. Equality Tasmania gave evidence to the Gender and Equality Committee in support of an automatic payment upon expungement, a fixed amount and more for an expunged conviction than an expunged charge, and said that redress will acknowledge and help remedy the injustice and deep harm endured by victims of our former laws. As the voice for victims, Equality Tasmania's evidence to the committee said, and I quote, "Charges and convictions under our former laws led to fines, jail, aversion, practices, involuntary outing, loss of jobs, loss of family, loss of relationships, interstate exile and suicide. Victims endured humiliation, shame and stigma, decriminalisation, pain and trauma. For decades after their conviction, having a criminal record made it much harder for those targeted under our old laws to find employment and housing. The government did this, and so it is responsible for repairing the damage," end quote. Mr President, the independent reviewers also said a payment would demonstrate the government recognises the harm caused and that the number of applications for redress is likely to be low. Again, quoting from the independent report, it said, "Given the low number of anticipated applications, the number of payments that would be made is likely to be limited, but such a payment would be seen as a genuine recognition by the government of its intention to recognise that these matters should never have been crimes and that there has been harm caused." In evidence to the committee, Equality Tasmania noted the findings of the independent review in relation to the number of people likely to be eligible for redress. As stated in Committee Finding 4.3, the independent review estimated about 100 people were charged under the relevant Tasmanian statutes from 1945 until their repeal. A handful of these people are known to Equality Tasmania. They are all elderly. However, there have been no successful applications for expungement so far. Mr President, let's hope that in providing a mechanism for redress, this will change. Whilst no amount of money can possibly make up for the harm and enduring suffering of those who were charged and convicted for what should never have been a crime. That's part of the reason why it was so difficult to determine a fixed payment figure to include in this legislation. I note that, as other members have, should we pass this bill, Tasmania will be the first jurisdiction in Australia to provide for redress, which is another reason why it was a difficult task to determine a payment amount. I note the committee took this task very seriously, listening to the evidence and looking at other redress schemes from across the world to carefully and sensitively determine the fixed payment amounts to recommend. I thank the Parliamentary Research Service for their assistance with this. I note the committee also received a submission from Monash University law professor Paula Gerber on the quantification of compensation following expungement from historical offences. Ms Gerber said, "It is vital that the amount of compensation err on the side of overcompensating. This is because a failure to recognise the severity of the harm suffered risks exacerbating the injury already experienced by the individual." I think that's a really important point, Mr President. Ms Gerber also said there are some core principles that should be applied. First, the sum should represent a genuine recognition of the harm suffered and allow those who were subjected to these egregious laws to feel a sense of justice and closure. She said that guidance on the quantum of compensation payable can be gleaned from how courts assess general damages payable to persons who have suffered a tortious wrong. There must be recognition of economic as well as non-economic loss and damage. Guidance can also be gained from looking at compensation that has been paid for general wrongful convictions. Based on her analysis, Ms Gerber concluded with recommendations as to the fixed amounts to be recommended by the committee to the Parliament, and I thank Ms Gerber for this very helpful analysis and evidence. Further, I thank the government for adopting the recommendations of the committee for inclusion in this bill. I also thank the government for accepting use of the term redress rather than ex gratia payment or compensation. Because, Mr President, language is important. The committee heard that through its inquiry, particularly through the Equality Tasmania submission, which said, and I quote, "Equality Tasmania uses the word redress to refer to the payment recommended by the independent review. We do not use other terms such as compensation or reparation. This is because the word redress carries a connotation of an injustice acknowledged and a serious desire to make amends for past wrongs. Compensation and reparation carry the connotation of providing financial restitution for all the financial and psychological harm caused by charges and convictions under the historic laws in question. In some cases, this might include loss of employment, jail time and/or aversion treatment. In such cases, the amount of compensation would likely be very large. In all cases, it would need to be individually assessed, which runs against the recommendation of the independent review." Equality Tasmania went on to say, "We also do not use the term ex gratia, even though that is used by the independent review. Ex gratia means out of grace, rather than a debt owed for an injustice. It implies the state has a choice about granting redress, which negates the independent review's recommendation that the payment be automatic upon expungement." Now, end quoting Equality Tasmania. Mr President, as I said earlier in my contribution, no amount of money is enough to make up for the harm and suffering. No amount could compensate. Language is important and redress is the appropriate term. As the committee heard, there are a number of compelling reasons why Tasmania should be the first state to provide redress, including that we were the last state to decriminalise homosexuality and the only state to previously criminalise cross-dressing. This has left a legacy of stigma and discrimination that is more recent than other states. That is, we still have the opportunity to more meaningfully right the wrongs of the past and show those who were victims of bad law we are truly sorry for what happened to them. And we should. In fact, Australia is a signatory to the United Nations International Covenant on Civil and Political Rights, in which Article 14.6 provides, and I quote, "When a person has by a financial..." I quote, "When a person has by a final decision been convicted of a criminal offence and when subsequently his conviction has been reversed or he has been pardoned on the ground that a new or newly discovered fact shows conclusively that there has been a miscarriage of justice, the person who has suffered punishment as a result of such conviction shall be compensated according to law unless it is proved that the non-disclosure of the unknown fact in time is wholly or partly attributable to him." End quote. I know that's a lot of words to process, but in short, to me, it says that we're doing what we're doing through this bill. Start that again. In short, to me, the covenant says that doing what we're doing through this bill also complies with our international commitments and our obligations to the United Nations. But ultimately, complex international covenants aside, we should be doing this simply because it is the right thing to do, Mr President. I note further from the briefings this morning that there is further need for consideration of further amendments to potentially provide redress to families who have suffered trauma as a result of these now expunged convictions as well. Because in passing this today, we're not necessarily acknowledging or responding to the fact that families have lost loved ones and their whole lives have been changed as a result of what happened too. Sadly, as we heard the other members say, some men are no longer here to apply for redress. Some ended their own lives. Such was the trauma of the conviction. So families under the existing provisions in the Act can apply for expungement, but this amendment does not provide for them to apply for redress. We would need to look at eligibility to apply, and the eligibility criteria would need further consideration, and I do urge the government to give consideration to this. Mr President, I'm not proud of Tasmania's past and the wrongs and suffering inflicted on people charged and convicted with things they should never have been charged or convicted with. But we can be proud of what we do here today and in the future by passing this law today. I support the bill.